Daily list orders, item 1.
Lordship, yesterday the delay matters were listed and Lordship has fixed, not this one, the series was listed, Lordship has fixed it for the 5th of January. Am I audible now, Lordship?
Those matters have been fixed on 5th of January.
Of January, it may be listed after that, Lordship.
Okay. So these are also matters,
Delay matters.
delay matters. Okay, it relates some issues of delay also there.
That is one of the issues.
Then let it also. Then it come on 5th of January then. Others have been
Later,
fixed.
After 5th of January, because that did,
This bench has been questioned only for this
No
matter.
problem.
Why not?
23rd list you have got? Yeah. Why don't you put another one?
yes.
You done? 15th. So let it come on 9th of January then.
Yes, Lordship.
And Mr. Mahmood Lane, Council for the Bar, also Ms. Anita for the state. They've been submitted at issue of delay also involved. And since other petitions have been fixed on 5th, the matter be listed on 9th of January. Same order also then item number 2 also.
Same Lordship.
Same order. Hard Ms. Chaudhary Lane, Council.
Lordship, actually, I am asking for a remand, Lordship.
Remand.
Yes, Lordship, the petitioner could not adduce the evidence of her brother, Lordship. So my main submission before your Lordship, if your Lordship can remand it, your Lordship, for adducing evidence of her brother's Lordship. Only on that point,
Say the
Lordship.
issue of delay has to be settled first.
Delay, I have explained, Lordship. She does not have any issue, Lordship. She do not have any children. Only her husband, and she is the only in this family, Lordship.
In the tribunal, who had adduced evidence in the tribunal?
Only the petitioner, Lordship.
And
PW1.
did you make an application that I want to examine this?
No,
brother?
Lordship, that proper advice was not given. I have written in my review petition, Lordship, that due to lack of proper advice, Lordship, only I want this, that she has brothers, Lordship. So any of the brothers may kindly be allowed to adduce
Yes,
evidence in her favor.
If
There is no family member.
Yes, just see, have a look.
I think Mrs. Burma will not oppose to this prayer, your Lordship.
At this stage, Lordship may allow her the interim protection, Lordship, but the matter may be.
Lordship,
Well, she's saying that you will be given interim protection, but
Matter
then
may be heard, Lordship.
Hmm.
interim protection already given.
already
Lordship.
given. She has
Yes,
already
Lord.
quoted. Hmm.
And
She
on
can
delay
wait
ground,
for few
Lordship,
more
in my
days,
para
Lordship.
5, I have stated that she doesn't, as there is no member in her family except her husband.
Hmm.
Para 5, Lordship, the husband of the petitioner is a cultivator and their family is dependent only upon the meager income derived from about 1.5 acres of their own cultivable land. The petitioner and her husband passed their days with much financial hardship, and as such, though the impugn order was passed on 25/11/2019, she could not approach this honorable court immediately. However, after much struggle, she managed minimum legal expenditure for filing the review petition, but in the meantime, the first wave of COVID-19 pandemic came, for which she had to spend the money for their survival, whatever she managed for legal expenditure. Thereafter, though the lockdown was lifted, but she could not make up the deficiency as she was totally indebted during the pandemic, and besides, the second wave of COVID-19 returned. However, now after taking loan from her relatives, the petitioner somehow managed some minimum legal expenditure once again and has filed the instant review petition, but in the meantime, a good amount of delay has occurred in approaching this honorable court. Hence, the delay which is found to have occurred was not intentional, and there is no negligence and or laches on the part of the petitioner, and as such, this honorable court may be pleased to condone the same in the interest of justice. And her only legal document, Lordship, GP certificate and school certificate, those were not proved, Lordship. So she is depending only on the evidence of her brother. And if your Lordship allow, the petitioner can adduce the evidence of those persons also, your Lordship. No proper advice was attributed to the petitioner. I have mentioned in page 11, Lordship.
Yes, Verma.
Lordship, in the review, she has to come up with that she had to place some new facts, important facts which were important, Lordship. She has no specific grounds. It's just the delay part which she has mentioned. Lordship, my prayer would still be, because the team has already discussed that excluding the COVID period also, there's a 4 months delay. And Mr. Kolita would like to address this court on the delay issue, Lordship.
Okay, then. Perfect. The 9, same order, same order.
Lordship, here also, we have gone to the petition. This matter was first listed on 3/8. Petitioner never appeared, Lordship. And no specific grounds are there for review, Lordship. Delay has not been mentioned, and the delay is for 77 days we have calculated. This matter may also be listed after the 5th of January.
My lord, time for the petitioner, some urgency from our side, my lord.
In
My
what
lord,
way?
the petitioner is a female person, my lord. My lord, I will pray for her some protection, my lord. The police is running after her.
Protection may be given,
Okay.
Lordship.
List hard, Mr.
A. Ali.
Lana Council. Also, Miss Consortium. It has been submitted that the similar issue, petitions with similar issues have been posted on 5th of January. According, let this matter be listed on 9th of
Lordship.
January as spread. So in the meantime, the petitioner who has been detained, you are in detention.
No, man, outside.
House. In the meantime, it is also provided that the petitioner, it has been submitted that the petitioner, if not detained, petitioner, in the meantime, it may also provided the petitioner may be allowed to remain on bail during the pendency of this petition. However, she will appear, 5,000 security, mobile phone also.
SP government.
Next item, Rajia Khatun. Yes. Oh,
In this case, my lord,
yes, notice have been
LCR
issued.
court for my lord, LCR not.
The records have been issued. Await records. Await LCR.
Reminder for LCR, Lordship.
Yes, await LCR list after next month. Next. Musamman
Item
Majma
number
Begum.
3. My lord, in this case, my lord, LCR is there, my lord.
LCR there.
My lord, 3 witnesses were examined, my lord, and one Gabra also examined, my lord.
Very good. I will keep for hearing then.
Yes, Lordship.
Since the records have been received, the matter will be listed for hearing.
Item number 4.
Joygun Begum. Joygun Begum. Anybody for Joygun? Yes,
Notice may be issued.
notice
Lordship.
record interim. Yes.
Item number 5.
Noor Bhanu.
Yes, Lordship.
Yes.
Lordship, the petitioner is declared as foreigners
Ah.
at post 25th March 1971 by the opinion dated 18/11/2021.
Yes.
Lordship, while she was born in 1986, Lordship.
86.
86, Lordship.
Okay.
Lordship, she was born and brought up at village Tilapara.
Since she was born in 1986, she could have come in 1971. Is it your case? No. What is your case?
Yes, Lordship.
Is your case?
Lordship,
She is born in 1986. Why are you declaring her a foreigner?
Lordship will examine this matter, Lordship.
Yes, tell us.
Lordship, actually, she was born and brought up at village Tilapara, Abhayapuri, and Lordship, the name of her grandfather has been recorded in the voter list of 1966 and 1970, Lordship.
How do you know that they are your grandparents? How do you know?
Lordship, kindly see annexer B and C, Lordship.
How do you know that they are your grandparents? Have you tried to prove the linkage?
Yes, Lordship.
How somebody has appeared in your favor in the tribunal? Witness? Any witness who had appeared in the tribunal?
No, Lordship, actually, kindly see annexer B and C, Lordship.
Annexer B and C. Then we have seen annexer B is a voter list.
Yes, Lordship.
A voter list you can get from anywhere. How do you say that these voter lists are of your grandparents? Has anybody come to the tribunal and said, yes, Has anybody given evidence? No. Any idea?
Yes, Lordship.
Who has appeared before the tribunal? Did you appear before the tribunal?
Yes, Lordship.
He appeared. Hmm.
Even DW2 also appeared, Lordship.
Who is DW2?
Nurul Haq.
Who is Nurul Haq?
Nurul Haq is her father, Lordship.
Very good. You said that because the father will know everything. The
Yeah.
father will know the daughter, the father will know the parents. Okay, we'll examine. Notice record
Lordship.
interim. What? What do you want? Tell us.
Lordship for interim.
Interim. What kind of interim you want? Huh? What is the interim period you want?
Lordship, her father's name is
Oh,
also.
what you said interim. What interim you want? What is it? Tell us. I will grant you. Brother is willing to grant. I am also willing. But tell us what is the interim you want? When you go to a restaurant, you sit down at the table.
Yes, Lordship.
Huh? Then you have to say, I want this idli dosa. Otherwise, the waiter will not tell you. No, otherwise they may give you rasgulla when you want a samosa. So you have to tell, no, you have to say, yes, give us chai, samosa or something.
Lordship, not to arrest and deport them.
Not to arrest and deport. Okay, very well. Okay. Shall not be arrested. But you appear, huh? 5,000 security, huh? And you ask her to buy a mobile phone. Does she have a mobile phone? Nur Bhanu Khatun. Does she have a mobile phone? No idea. You tell her, if she doesn't have a mobile phone, tell her to buy a mobile phone, give the phone number to the SP. SP of which border of? SP of which district?
Abhayapuri district.
Abhayapuri. Okay. To go and give the mobile number to Abhayapuri, SP border. Moegaon. SP Moegaon. Check kar lena.
Item number 6.
Javeda.
Wait, Your Lordship.
Yes.
Lordship, it's a contested matter, Lordship. Order is at page number 42. Moreover, DW2 is my elder brother.
Elder brother.
Yes, DW3 is a headmaster and DW4 is a Latmandal, Lordship.
DW2 is your brother.
Yes, Lordship. Elder brother.
Elder brother.
Yes, Lordship.
Yes. Elder brother would know. Okay,
Family.
notice record interim. Next.
Item number 7.
Yes.
In this case, Mother, the mother has deposed on.
Mother has deposed.
Yes, Mother.
Yes, mother has come, then why don't believe the mother?
At this stage, notice may go, Lordship of examiner.
The evidentiary value of mother is so much.
If it has been proved, Lordship.
It's-
Even King
Mother
Solomon,
is a-
even King Solomon, the wisest king known
Yes,
to be,
Lordship.
he would believe both the mothers. Not only one mother, both the mothers. So he said, okay, then half. Take. That's the King Solomon. So mother, when the mother appears, that's all. Okay. Notice record interim.
Item number 8.
Please, Your Lordship.
Yes.
It is a contested case, Your Lordship. And Your Lordship, I had reduced the electoral roll of 1966 containing the name of my father and uncles, Your Lordship, and thereafter some subsequent electoral rolls, Your Lordship.
Examine, Lordship.
Notice record interim.
Much obliged.
Item number 9.
Basiron.
May I please, Your Lordship? My lord, here it's a contested matter. An impugn order is at page 34, Lordship.
Page
I have-
34.
Yes, Lordship, and
What is wrong with this?
my father has adduced evidence as
His father
DW
came.
father, then my headmaster, where I studied, headmaster, altogether 7
Yes.
witnesses, Lordship,
Examine,
and no
Lordship.
discussion of DW2, Lordship.
But father is not a direct witness. Only the mother is a direct witness.
So father is also,
No, father stands outside. He doesn't know. The mother will know.
and linkage document also is, but DW no discussion, DW2 no discussion, why it's discarded.
Item number 10.
Notice record interim.
My lord, in item number 1, actually review petition, in that, I apologize for that. Review petition I did, so my name was there. So review petition was allowed by this honorable court. And now the main case came in writ petition. Writ petition, actually, my name is not reflected.
Oh, I see.
This is the reason I missed out the matter,
Then what is it? What is to be done in the one?
because already.
We have already issued notice.
Yes,
we have
Lordship, but
already-
my
you will-
name may be reflected.
Reflected. Okay. Item number 1 will likhna. Miss so. Notice Even we gave you interim.
Yes, Lordship. Because my name is not reflected in
Okay.
deeply applied.
Then
I don't know what it-
10 is Jahuruddin.
May I please, Lordship, sir?
Yes.
Well, contested case, my lord. In this case, my lord, the petitioner himself examined as DW1 and his elder brother, my lord, as DW2, my lord. As because her mother, parents were died earlier, my lord. That's why his elder brother, my lord.
Yes,
can-
notice
Examine
recorded
lordship.
here.
Item number 11.
Bimala Das.
May it please your lordship. Lordship is a contested case. The proceeding had exhibited 1965 voter list of the father and his nephew also deposed before the tribunal.
Nephew. Nephew.
Nephew.
What the nephew will know?
1965 voter list was
How
also.
the nephew will know? Nephew is a bacha when you are born. No, but nephew has not come into existence when you are born. So how will you know?
1965 voter list was also exhibited. That was
Bimala.
disbelieved.
Okay.
Examine lordship.
Notice record interim.
Item number 12.
Govindo. Yes, Govindo.
My lord, the Govinda is a person of 74 years old, my lord, and he has himself been recorded as voter since 1966, my
Then
lord.
why did not believe?
Huh?
Why the tribunal did not believe?
The tribunal, my lord, says, I have got two names, my lord. Tribunal said, you are Govinda, not Chandrahas. He has got two names, my lord.
He was marked
But
D,
I claim
lordship.
that I have got two names. But
You
tribunal
have got
said-
two names.
Yes.
What is the name? First name is
First name is Chandrahas Saha,
Chandraha Saha and the second name is
Govinda Saha, my lord.
Govinda Saha.
And he was eventually
Madam-
marked D and the reference was
You
lordship.
you go to America, they will detain you. I said you are impersonating. You are
No, no, our Hindu people usually have got two names, my lord. I
Hindu
also
people have
got
two
names.
different names. Chandrahas,
And Govinda, my lord.
Govindo.
And Gobindo, he is recorded as a voter in municipal of Bhing, municipal committee of Bhing, my lord, with his wife.
You have also two names.
Yes, he
You
has
also
got-
have two names.
Yes, my lord.
You also have two names.
Yes, my lord.
Oh, that is why you are able to. But I have
One
only
is-
one name. That's
One
the
is known as
confusion.
Gupta, my lord, and the other
Huh?
is the Gupta.
Okay.
What?
Okay. Let us believe him. He said two names are there. Every Hindu, many Hindus also have two names. So we'll see, examine. Okay. Notice record interim.
Very good.
Item number 13.
Yes, Abu.
May I please your lordship. Lordship is an expertise order, my lord. I have challenged this particular order. Before
When was the expertise order passed?
my lord, on 26, my lord. 26/8/2022. my lord.
Then why didn't you go?
My lord, before going to the impugn order, my lord, lordship will kindly have a look at the order sheet. How the order was passed, my lord.
Page number?
Page number, my lord, 45, my lord, next and 9, my lord. My lord, I filed a written objection, my lord. Accordingly, my lord, my petition was allowed and the next date was fixed on 12/9/2022 for evidence of proceeding, my lord. In the first order, my lord. Thereafter, my lord, and a remark has been given, my lord, that later on, he mistakenly said that the proceeding had given written statement. In fact, he had filed a written objection. Accordingly, my lord, this petition was not allowed. Later on, my lord, on the same day, my lord. Then he had passed this particular expertise order in a separate, my lord, order sheet, my lord, that is page, my lord. 54, my lord, annexure 11, my lord. The procedural lapse is there, my lord, in the reference
Yes,
inquiry report, my lord. Nothing has
Chance may
been
be
filled up.
given, lord.
you can, I think we will remand this, huh?
Yes.
Because, okay, Mr.
Zed Ahmad, my lord.
Thane Council will know. Also, Ms. Venture. Considering the peculiar nature of the case is revealed in the record, we are of the view that the matter requires to be remanded to the learned foreigners tribunal for fresh reconsideration. It has been submitted that the learned tribunal has not properly applied, it has submitted that has not properly submitted that it appears that from the record, it appears that the matter was listed for consideration on 26/8/2022. In this sense, in his appearance, he challenged the order dated. From the record, it is seen that the matter was fixed on 26/8/2022 for passing an ex parte order declaring the proceeding to be a foreigner post 25/3/1971.
4 chances were given lordship for filing WS, but because of the illness, he couldn't file.
He was ill, my lord. He met with an accident, my lord. That has been rightly described, my lord, in the petition. my lord.
On that day, the petitioner was present before a tribunal file an application number, petition number 2764, praying for vacating the earlier ex parte order to allow him to file written statement, which is already ready. Accordingly, the learned tribunal allowed a prayer of the petitioner. Full stop. The matter was accordingly listed for further consideration for recording evidence of the proceeding on 12/9/2022. Later on, the learned tribunal recalled the said order on the ground that the petitioner had not filed a written statement but only a written objection, stating that the investigating officer had not conducted investigation properly, because of which it was submitted that on the ground of which it was submitted, it was prayed that the proceeding be dropped. Learned tribunal, on such submission being made, learned tribunal took the view that it would not be possible to drop proceeding in MHS as per the reference made by the SP border Morigaon. It is mentioned therein that the suspect within bracket OP could not produce any document to prove his nationality. And that it has been indicated that he entered India after 25/3/1971. The learned tribunal further went on to observe that if the investigation had not been conducted properly, there was no reason why the OP took 5 days to file written statement. The learned tribunal also found fault with the proceeding in not raising the issue at the initial stage. Accordingly, the tribunal proceeded to examine the matter. Proceeded to examine the matter by not proceeding the matter and declared the petitioner to be a foreigner of post 25/3/1971. It has been submitted that the aforesaid vacillating mind of the tribunal cannot form the basis of an opinion. We are also in agreement with the submission advanced by learned counsel for the petitioner. Once the tribunal had taken a decision to recall the ex parte order and allow the proceeding to file a written statement, it could not have been recalled in a manner it has been done as reflected in the impugned order. The reason for recalling the impugned order also was that the proceeding did not raise objection about the defective investigation, and that also was not raised at the earliest. We have the view that the aforesaid reasons assigned cannot be the basis for reviewing the earlier order to allow the petitioner to file written statement and for recording evidence. The tribunal must be consistent in its decision, whether it is right or wrong, that can be examined. That will be subject matter of consideration before another legal forum. But the tribunal cannot keep changing his opinion on the same day, as appears to have been done in the present case. Keep changing or reviewing his own order on the same day, as have been done in the present case. Accordingly, we are of the view that, next para, as to whether the investigation had not been conducted properly or not is an issue which can be raised by the proceeding at a time of hearing also.
Right.
Further, accordingly, we are inclined to allow this petition by setting aside the impugn order at 26/8/2022 with a direction to the tribunal to allow the petitioner to file his written statement and adduce evidence, and thereafter the tribunal, after hearing the evidence, considering after considering the evidence on record, and after hearing the petition proceeding, will pass an order as to the nationality of the petitioner. For this purpose, according to the impugn order is set aside, the matter is remanded to learned tribunal, which will proceed in accordance with law as observed above. Next, the petitioner will accordingly appear before the tribunal on
first week of January.
1st of January. Don't say 1st of January, give a date.
The calendar
You are going to appear, not us.
10th of January.
10th of January.
Right.
On 10th of January 2023, the petitioner, however, will report, but the petitioner also will report before the SP border,
Morigaon.
Morigaon, and will be allowed to remain on bail during the pendency of the proceeding, subject to furnishing of bail bond rupees 500 security level. Mobile phone also, mobile number.
I'll furnish the mobile. High level.
Item number 14.
Here, elder brother has been examined.
Notice record interview.
Supplementary list for motion, item 16.
What's up? Item number
16.
16.
16. Supplementary.
Jainuddin.
Invited back, Lordship. The directions of the Honorable Court was not taken into consideration by the Tribunal, Lordship. So
And Mr. Lane Counsel for the House Lane Counsel, this petition has challenged the impugn order dated Swenso passed by Lane for impugn order dated page number.
Page number, Lordship, 96 onwards.
Impugn order dated
Order dated
page.
page 96.
Page 96.
Order dated 38/2022.
Page number
96.
impugn order dated 38/2022. On the ground that the petitioner challenged the said order on the ground that the tribunal had not at all considered the observation direction issued by this court in WPC number 7084 of 2017. 7084 of 2017 passed on 14/6/2022. Ms. Verma also has fairly submitted that it appears the learned tribunal has not given proper consideration to the direction and observation made by this court, because of which the impugn order appears to suffer from certain appears to be perhaps for which it will be difficult to sustain the impugn order. We have also gone through the record order of this court by order of this court passed on 14/6/2023 in WPC number 7084/17. The learned tribunal does not appear to have given any consideration to the various observations made by this court, in our view, the tribunal could not have ignored the same. The tribunal, on the other hand, decided the matter purely on the basis of the record, purely on the basis of the inquiry report in which the petitioner has been shown to have been resident of village Pakandia of district Moimansingh, Bangladesh. In our view, the tribunal could not have arrived at such a decision in a case. The said finding of the inquiry report has been challenged by the proceeding.
Right.
And if the tribunal has to assume the said finding of the inquiry report to be correct, there is no need for further for consideration before for any further consideration before the tribunal. In a case, the petitioner has specifically pleaded that he is an Indian, not a resident of the said Bangladesh, said village Pakandia of Bangladesh. So under the circumstance, we are satisfied that the tribunal, the impugned order dated 30/8/2022 passed by the Learned Tribunal cannot be sustained in law for the reason that the reason given is cannot is the reason given is the reason given assigned by the by the tribunal is the reason given by the tribunal is based on the reason given is based on certain finding which is a subject matter of dispute, and without properly deciding the correctness of the finding of the tribunal, finding of the inquiry officer, the tribunal could not have accepted the said finding to be correct and proceed to declare the petitioner as a Bangladeshi. We also have noted that the Learned Tribunal appear to have not appreciated the observation and direction issued by this court in WPC number 7084, which the tribunal is required to do so. In as much as the tribunal cannot ignore the observation and direction of a higher judicial forum. Under the circumstances, the present petition is allowed by setting aside the impugned order dated 30/8/2022 passed by the page 96. Tribunal is directed to consider afresh the matter by taking into consideration the observation made by this court in WPC number 7084 of 2017 and pass an order, reason order, by taking into consideration the various evidences which have been brought in the court. The tribunal cannot accept the finding of the of the inquiry report as gospel truth without considering the evidence laid by you have laid evidence in this petition.
Yes,
Evidence laid by the petitioner in challenging such a finding of the inquiry officer. With the above observation.
Proceed in the earlier order. Actually, regarding this aspect of the matter has not been whispered or mentioned by the tribunal lordship. In the earlier order, there is no mention about this address, etc. That he has address in Bangladesh or such thing. There is nothing in the earlier order, but this is new finding of the tribunal.
Lordship, the opinion
Next
says Lordship will come to page 97.
We also have observed that the tribunal, while that it also we have also observed that in the first opinion rendered by the tribunal, page number
66, Lordship.
Page number 66.
66.
The first was the issue rendered by tribunal on
22/9/2017.
22/9/2017. The Learned Tribunal gave his opinion based after considering the evidence record, which was subject matter of challenge before this court in WPC number 870.
7084.
7084.
84.
And this court having found fault with the reasoning, allowed the petition, allowed the said petition and directed the tribunal to consider afresh the matter. Unfortunately, when the tribunal reconsidered the matter, the tribunal, rather than reconsidering the matter on the basis of observation by various court, went on to assign a different ground, different and new ground, as mentioned above, that in the inquiry report, the petitioner is shown to be a resident of Bangladesh. In our opinion, the tribunal could not have, though the tribunal could have given fresh reasons, new reasons for coming to his own conclusion, but certainly it must give his reason with reference of, first it must also have, it should have also considered the reason, it should have also considered the aspect which have been directed to be considered by this court, which having been not done, we have the impugned opinion cannot be sustained. That also add it, huh? Okay, next.
Lordship will fix up a time, Lordship.
The matter is demand that the petitioner will appear for the tribunal on, give a date.
10 January.
Huh?
10 January.
Then thereafter, the learned tribunal will reconsider matter afresh and pass a fresh order or fresh opinion. Till then, you have been given some interim order earlier, no?
Yes,
Huh?
yes, earlier there was interim order.
What interim order? When?
Till disposal of the petition, earlier
Okay.
petition, Lordship.
The earlier interim order passed by this court on?
And that was,
Huh?
order dictated.
Interim.
17.
Not 14, yes, that is annexed here. 2011-2017, the first order was.
Therefore, during the penance of the petitioner will be allowed to remain on bail, on punishment of bail bond of rupees so and so. To the satisfaction of the SP border, Morigaon. Fingerprint, huh? Biometric, mobile phone also, mobile phone number. Also. Yes.
Item number 17.
Jahan Ali.
Met please, Lordship.
Yes.
The impugned order passed by the tribunal, Lordship, will get page 93, Lordship.
What is problem with this?
A problem is that there is some discrepancies, minor discrepancies in the name of the father and grandfather of the.
What is the minor discrepancy?
Lordship, kindly get page 99, Lordship.
Yeah, tell us the name. What is this?
Ramzan Mollik
And
Ramzan Ali Mollik, Ramzan Mongal.
okay.
Examine, Lordship.
Notice record interim. Yes.
Item number 18.
Lordship, in this case, the learned tribunal has rendered its opinion, Lordship will get one.
Chakera Bewa, in Chakera Bewa.
I'm old age lady, Lordship.
Notice record interim.
SP Dhobri in both the cases.
SP.
Item number 9.
Rahim Ali.
Item 19.
Yes, Rahim Ali.
May please, Lord. My lord, in this case, my lord, reference was, my lord, in favor of the petitioner, saying that he is a citizen of India, my lord. And it was forwarded to the, my lord, Foreigners Tribunal. Foreigners Tribunal, my lord, proceeded expertly. They are from Barbados, my lord. They stayed some time at Guwahati, and it was proceeded expertly, my lord.
Okay. Also notice record interim.
In the meantime, my lord, in terms of interim expertly order, my lord, the FIR has been filed and they have been taken in custody, my lord.
In the interim, the petitioner maybe is directed to be released on bail, who has been detailed in connection FIR number, so give detail, because registered in terms of on the basis of the impugned order dated so.
Item number 20.
My lord, same, my lord.
Same.
Lost.
Yes.
All right.
He also interim.
Lost.
Also detained.
He's also in jail, my lord.
Yes.
Daily list for admission. Item number 15.
Atabuddin. What is Atabuddin? Records have come. Since the records have come, matter listed for hearing. Next. That's all.
List over.
Next.
It's a long pending matter, my lord. Dismissal is of 1985, my lord. So therefore, there is the urgency, my lord. Okay.
Yes, next.
Daily list for admission item 1.
My lord,
What is to
here,
be done today?
here also the issue is central organization
Oh,
case.
so,
my lord.
so therefore it will be referred, no? So,
Yes.
wait, huh?
Yes.
Or Mr. Hussain, who submits that we may await the decision of the honorable decision of the larger bench of the honorable Supreme Court in reference to central what is it?
Organization for railway electrification.
Kindly give the citation. Yes. Next.
Item number 2.
Yes.
Time being this matter, my lord.
Okay.
Senior
Next.
is on leg, my lord.
Next, item number 3.
Item number 3.
Yes, Mr. Sharma. Eastern Cargo. Yes, what is to be done today? Yes.
We are for the respondents, madam.
And who is for Mr.
Procedural Sharma is for the petitioner.
He is not present today. What is to be done today?
Must be on legs, my lord.
It is contested.
Yes, my contested.
We wait for some time. Then yes,
My lord.
Manishankar,
Item number 4.
Dekka. Yes. What is it?
Appointment for arbitral lordship.
Means, have you issued notice?
Yes, lordship. Notice has been issued, lordship. They have appeared and also filed their affidavit, lordship.
Stating what?
They think that some allegations are false. And so for appointment of arbitrator is concerned,
No.
they have no objection.
Okay. Why is that? Why is that? Why is that? Some they have no objection.
No, they verbally they have told that the council told that, but
No, but-
affidavit they have not stated anything disputing this for
the
appointment
affidavit-
of.
In the affidavit, what is that? What is the case?
Paragraph number 5. Lord.
Affidavit is that we don't have the affidavit here. The file affidavit. But I don't have the affidavit. When did you file?
It is filed on 28/9/2022. Small affidavit. Lord.
Filed by whom?
Filed by the respondent, lordship.
What is the name?
Nowadays serial numbers is there start from 60.
From 60.
Yes, Lord.
60.
60.
I don't know. Just have a look. I don't know whether it's. I don't see the affidavit. Next. Just
Yes.
just check. I don't know. I have not seen the affidavit. Yes, Nick.
Item number 5.
What is to be done? Right, Ani?
Yeah, please.
My lord, we will be filing affidavit during the course of the day, my lord. Lord, may.
They are yet to file their response, your lordship.
Okay. Mr. Gupta, Learned Standing Council Railways, no?
My lord.
Praise for.
The-
Since he will file the response today, least accordingly after a week. Next.
My lord.
Next.
Item number 6.
Anybody for item number 6? 9. Then item number 7.
Item number 7.
9. Item number 8.
7.
7, but you were there, but the other side not there. No one was present for the petitioner. 7. Then number 8.
Item number 8.
Anybody?
My lord, we were asked to produce the record and we are yet to receive the record, my lord, the original record.
Please.
Lordship, this is a 2019 matter and respondent number 5 is going to retire in February, Lordship, and they are not, Lordship, producing the records still.
Means
H. Rampi, my lord.
empty place for some time for production record. Let it be produced without fail next week. I give a next week.
9th of January or 4th of January? 4th of January.
Before vacation, Lordship,
Publication due to return. Next.
21 January. So 21 December.
Next.
8 and 9 over.
Over.
Time being 2.
Yes, then time 2. No one.
Please, your lordship.
Item number 2.
Yes.
What is to be done today? Yes.
Lordship,
Yes, yes.
Sir, I am for the railway lordship.
Ah.
Lordship, our argument is lordship, the matter may be liable to dismiss lordship because they not follow the general condition of contracts.
What
Lordship.
about yes?
Lordship, we are filing a written argument. Your Lordship may kindly
Last.
quote
Give a
it.
copy to Mr.
Yes, of course, we'll give it.
Next week then.
Highly obliged, Lordship.
No?
After vacation, lordship. 4th of January,
After this? Okay.
4-1.
Joint prayer list again.
Item 3,
Much obliged.
You are present again, but again nobody is here.
My lord, he is also not picking up the call, my lord. Must be in on lags, my lord.
Next week then. Yes. Next.
21-12. Item 4,
Lord, I will not be present.
Next item.
Affidavit is not
4-1.
there, Lordship, on record.
4-1.
4-1.
Call for the record.
He's coming, Lordship, my lord. Respond. 4-1.
Affidavit. But can we refer to the arbitration? No.
Yes.
Okay. Mr.
Yes, Taka.
Also Mr.
BP Boral.
We were Lane counsel for the respondent. When this matter was taken up, it has been submitted by Lane counsel for the parties that they have no objection to the appointment of an arbitrator by this court. Accordingly, in view of the submission, Honorable Mr. Justice, whom do you want to appoint? Mr.?
Lordship, both the parties held from the upper Assam. So there is a district judge Raktalal Das.
Okay.
He's a panel arbitrator. Lordship.
Okay. According to the Sri Raktalal Das and so retired district judge of Assam is appointed as a arbitrator to settle the dispute between the parties to stop. According subject to his consent and also absence of an impediment is contemplated under section 12 of the Arbitration Conciliation Act. To stop. On the learned arbitrator may be duly informed by this registry. Parties also intimate about this order. Intimate with a copy of this order. And the learned tribunal will accordingly proceed with the arbitration proceeding. You want to appear before them or you want to be sub notice?
Notice will.
Then notice will go on again.
Parties will directly appear.
Okay.
Within a period of
Parties submitted, they will appear for the learned arbitrator within a period of 1 month. And thereafter, the learned arbitrator will decide with the arbitration in accordance with law. Petition stands disposed of. Next, yes, any other?
In item number 6, I am appearing, my lord, for the railways.
But nobody is there for that.
Yes, my presence might be recorded.
Okay, Mr. Though no one is present for the petitioner, Mr. B. Sharma is standing counsel is present.
Item number 9, your lordship.
Item number
9.
And then with Nasiruddin, no?
18-9.
What is this?
Nasiruddin. Yes.
Nasiruddin.
Yes,
What
lordship.
is this matter about?
Lordship, this matter what happened? Respond number 5, your lordship. Earlier respond number 5 who has been expired. Selection committee. Now new selection committee is there. Earlier selection committee is not receiving any. Council of the earlier selection committee is not receiving any affidavit or whatsoever. So best notice may go to the respond number 5. Lordship.
Okay, it has been submitted by Mr.
I
will Lane counsel for the petitioner that fresh notice will be required to be served upon the newly constituted selection committee. That is respondent number 5. Accordingly, let fresh step be taken.
Lordship, justice may be allowed.
Justice is permitted.
Lordship, item number 3, lordship.
Yeah, what do you want?
My lord, he has come, my lord, so he was on legs on. I was on legs, lordship. Is it dismissed for dismissed?
No. No dismiss.
It's on 4-1.
It is
4-1, my lord.
another date, yes.
List of